Good afternoon, everybody. Thank you for coming. My name is Don Wycliffe. I'm a faculty member here at the Loyola School of Communication and the moderator for this afternoon's panel, which is a co-production of the Loyola School of Communication, the Headliners Club of Chicago, and the McCormick Foundation. And I'm grateful to all of them for putting together a panel of this magnitude on a topic of this importance. Concern to us today is, if not unique in the nation, then at least highly unusual. It forbids anyone to make an audio recording of conversations in a public place without the consent of all those involved in the conversation. And most controversially, it forbids such recording of police officers or presumably other officials under pain of a potential 15-year prison sentence. So you're in Daley Plaza on a lovely spring day and you see a police officer confront someone for an offense against the public peace and order. You whip out your cell phone, smartphone, equipped with video and audio capability. I'll bet you almost everybody here has one and has done something like this at one time or another. Standing a respectful distance away, you press the button and begin recording. You're legally free to videotape the incident. You're free to take still photographs. You're free to make copious notes and using your high school shorthand to take it all down verbatim and then to publish it. But you can't record the audio under pain of prison. Why? I'm hoping our guests this afternoon will be able to enlighten us on that. I want to introduce them to you. On my immediate right is Superintendent Gary McCarthy of the Chicago Police Department. Superintendent McCarthy came to Chicago last summer from Newark, where he was police director. Before that, he was for many years a member of the New York City Police Department and the son of a police detective in New York. He rose to the highest ranks in the department and was in charge of their CompStat program, which uses statistical analysis of crime to suppress crime. And he enjoyed enormous success when he was chief in Newark, and Mayor Rahm Emanuel recruited him here for the toughest job in the city, Mayor Emanuel's being the second toughest. Next to him is Lucy Dalglish, Executive Director of the Reporters Committee for Freedom of the Press, possibly the foremost defender of press freedom in the nation. Ms. Dalglish worked for 13 years as a reporter for the St. Paul Pioneer Press and was a trial lawyer at a Minneapolis law firm for several years before joining the Reporters Committee in 2000. And to her right is Harvey Grossman, Legal Director of the American Civil Liberties Union of Illinois, which has mounted one of several challenges in the courts to the controversial section of the Illinois Eavesdropping Act. Mr. Grossman is a graduate of Northwestern University School of Law, and before joining
quite frankly, it puts us in a very bad position. And then, you know, protract that out a little bit and talk about, you know, a 25-year-old young man or woman who just graduated a police academy. I mean, the life experience issue that comes into play, it's a big deal. So keep that in mind also.
Even if we identify ourselves?
I don't know how to say it any different, but you know, we get put in the middle. That's why we have Supreme Court decisions. And by the way, just think about the process that you have to go through to change a law, right? So it's not black and white on the ground. It's just really not that simple. And I need everybody to kind of take that in mind. And when we're talking about the common law right of inquiry, as has been raised, we ask questions and we determine whether or not it raises our suspicions to the next level, and that's how we conduct investigations. So none of this is black and white or clear. So let's keep that in mind also.
Yes.
If it's not black and white and clear, what would you advise journalists, citizens
I would advise people to do what it is that the law spells out, which is if it spells out in the state of Illinois that you can't do this or that, don't do it, because that means you're subject to arrest.
But if we're about in a case, why don't you just have, one of that recorded officers in the act of trying to, well, what they thought was trying to commit crime? What should a person do in that case?
Well, what does the law say? I think we've already spelled that out.
Other reactions from
Other questions?
Well, if I could react to that, I agree with the superintendent. The law is pretty clear about recording, and they have to follow the law. In this particular case, you folks don't have a problem with the police. You have a problem with the law. And the answer to that is political. And you need to make a compelling case to your political leadership and get the law changed. Or make sure that challenges are brought in the courts. I think it's illegal. But I personally would not expect the police to interpret the law when, for example, if the Seventh Circuit and the Supreme Court go the other way, then your redress is political. I personally think both of these courts are going to throw this law out. At least I hope they do. But I would not expect the police department to fix this. Now, where I think you actually have bigger problems is in these areas of general protest activity, targeting journalists and others who are trying to cover these stories, particularly photographers. These are far more troubling. That is not a political, I would not be looking for a political solution to that. That is just a situation where journalists have to be educated and citizens have to be educated to what their rights are, which are substantial. And police need to be educated as to what they can do and what they can't do at these protest and demonstration sites.
And
Don?
I would add, if I could, I would add to, in response to that, there is a concept in constitutional litigation called pre-enforcement challenges. That means you challenge the law before you've been subject to prosecution, or arrest, or charges at all, and that's what the ACLU did here. So in terms of our approach to this, we did not go out and knowingly violate the law and subject ourselves or our staff members to prosecution. And we did not sue the Chicago Police Department, though they have had multiple arrests under the statute for the conduct that we're challenging. We viewed it rather as a matter of enjoining the prosecutor who enforces the law. Now that is, I think, I don't want to give too many lessons in our form of government, but there is prosecutorial discretion. I think that law enforcement frequently exercise some discretion in what they enforce or don't enforce, but be that as it may, there clearly is prosecutorial discretion. And State's Attorney Alvarez has indicated through 3 prosecutions now her intention to prosecute this conduct under this statute. And so she did not decide to throw those charges out, which prosecutors do all the time, reviewing minor offenses resulting in no serious injury to anybody, no damage to property. And so she has made a decision to go forward with these prosecutions, and so we felt that she was an appropriate defendant and is defending, and she is in fact defending the